Hello, everyone, and welcome to this new Privacy Rules podcast. Today, we are not going to record the classic Meet the Member podcast. In fact, we have two members with us that are Padraig Walsh from Tanner David in Hong Kong and Kim Walker from Shakespeare Martineau in UK. The reason why we invited two members is because we would like to discuss about two very interesting and recent cases related to airlines data breaches. The first one is the Cathay Pacific that has been discussed during the month of June. And the second one is the British Airline intention to fine that has been published by the ICO in the month of July, the 8th of July, if I'm not mistaken. So we would like to have an overview of the two cases and see why and which were the decisions of the two commissioner offices that have been pretty different from the one to the other case, and probably that highlights the differences between GDPR and not GDPR countries. So without further delay, I would like to turn it over to Padraig in order to see what happened in Hong Kong.
Hi, Alessandro. Good to be in touch again. So let me kick off and tell briefly the story behind the Cathay Pacific data breach. So to do so, you have to wind the clock back to 2014. Then there was a cybersecurity attack, which attacked a particular vulnerability in the Cathay Pacific systems, went undetected for a long period of time until 2017. In 2016, there was a second cybersecurity attack. So there were actually two attacks that Cathay Pacific suffered. Now, the kind of systems that were attacked, one was in relation to airline member systems, so loyalty card programs and so forth. And another was related to remote access for website functions related to the Cathay Pacific websites. Now, the type of personal data that was, that was captured or that was accessed as a virtue of the breach was identification document, things like name, address, identity card number, passport number. Nothing related to financial or credit card data or transaction data of that nature, but flight information and identification information. The identification of the actual data breach occurred in 2017, in March, and was notified to the authority here on a voluntary basis in October of last year. So there was a period of just over 6 months before notification was made to the Privacy Commissioner. So what I should do there is maybe pause, because I'm also really interested in hearing what Kim knows of the story of the British Airways data breach incident.
Mm-hmm. Thank you, Padraig. Interesting, there are definite parallels. I mean, not just that they're both airlines. We know a little bit about the facts behind the British Airways data breach, but at the moment, of course, the announcement that's been made is of an intention to fine. The announcement was made because British Airways is a listed company, or its parent is, and so it had to make an announcement to the stock exchange, which meant the ICO was forced to make an announcement, or decided to make an announcement at the same time. From what we can tell, there was one of the classic data breaches. A fake website was set up, and British Airways passenger details were effectively diverted to and harvested in a fake website. About 500,000 customers had their name and address details, their login details, their travel booking details, and importantly, some of their payment card details effectively stolen. The UK's ICO took charge of the investigation under the EU's one-stop shop regime, because actually the customers came from a number of EU member states, but the ICO has taken charge of the investigation, and the intention apparently is to fine British Airways the grand sum of £183.3 million, which is 366 times larger than any previous fine imposed for or by the ICO, of course, under previous legislation where the fine was limited, but it's still a very large number. And I don't know how that compares with the intention to sanction through the Hong Kong authorities.
Well, actually, this is one of the interesting points of difference is that the Privacy Commissioner in Hong Kong doesn't have a fine or a penalty sanction that he himself can administer. So the only thing the Privacy Commissioner can do in Hong Kong is to issue what's called an enforcement notice, which the Privacy Commissioner did. So the Privacy Commissioner initiated an investigation, and the report arising from that investigation was published in June of this year. It took a bit of time for that to be pulled together. There was, I think, 10 different rounds of questions and answers between the Privacy Commissioner and Cathay Pacific, until the Privacy Commissioner was satisfied that it had enough information to move forward to prepare its final report. And in that report, the report essentially gave what's called an enforcement notice to Cathay Pacific, which gives Cathay Pacific a list of things that Cathay has to do and a period of time within which it has to accomplish those tasks. And the way it works in Hong Kong is that if Cathay Pacific fails to comply with the enforcement notice, then there may be some sanction or penalty that might arise from it. But there isn't an automatic notice of intention to fine in the same way that the ICO has been able to do with BA, which is actually, that might be one of the points of change, hopefully, well, depending on your perspective, that might arise in the future in Hong Kong.
So if I understood well, Padraig, you are mentioning that one of the differences is related on the commissioner powers from one to the other case. In this case, the Hong Kong commissioner has to follow certain steps before to issue a fine. That is something that is not required or appears not to be required for the ICO, if I'm not mistaken.
Well, it's technically actually a little bit different, because what happens if you don't comply with an enforcement notice is that it's an offense. So it becomes a criminal offense. So what the Privacy Commissioner would then do is report the matter to the prosecution authority, who would then prosecute that criminal offense in the courts. So the Privacy Commissioner himself has got no ability to impose a fine. And it's one of the limitations. As I said, this depends on your political persuasion. You know, Hong Kong is very much of the free economy type of, so that in UK terms, you might say it's the Tories gone mad. So it's very much of the, free economy type approach. So in that sense, there isn't a desire, or there hasn't been a political will to say that Privacy Commissioner would have a fine generating or fine imposing authority of his own discretion. And that can be a limitation.
Of course. And what was the difference with the ICO? Because I think the ICO can directly issue a fine if there is an intention for the moment, but it's possible that this intention will become something real in the near future.
Yeah. The Hong Kong regime sounds very much like our data protection 1998 regime, where a fine really was only issued if an enforcement notice wasn't complied with. Whereas now, obviously, with the GDPR, the possibility is the Information Commissioner itself can fine, or any supervisory body around the EU can issue fines of up to 4% of global turnover, or 20 million if that's higher. Or in this case, if it turns out that the British Airways breach was simply, if I can put it that way, a security breach, then the maximum fine is 2% of global turnover, or 10 million euros. So it looks, as I say, if it turns out that the breach was simply a failure to take suitable security measures, look after personal data, then the maximum that British Airways could have been fined is 2% of their turnover, and 183.3 million is apparently about 1.75% of turnover. So this is sort of 75% up the maximum tariff.
Well, was that a surprise, Kim? Because it's a breathtaking number. Was it a surprise in circles in the UK and in the EU?
It was, well, it was a surprise to me, let's put it that way. Not that they were fined, but the amount of the fine. The ICO, Elizabeth Denham, our information commissioner, highly respected, had made all kinds of pronouncements that, you know, fines are not what will change business models. I think she said, hefty fines are reserved for those who persistently, deliberately or negligently flout the law, and she's got no intention of changing her proportionate and pragmatic approach after the 25th of May. On the other hand, you know, and frankly, the markets weren't terribly surprised by the British Airways fine, because the British Airways share price hardly flickered, or it flickered and then resumed back to where it previously was. And of course, the same thing happened with Facebook in the US when they did their deal with the FTC to pay them $5 billion. Again, the Facebook share price hardly flickered, which makes one wonder whether regulatory fines are becoming thought of by the markets as a sort of cost of doing business, which is a slightly worrying thought. Because the GDPR says in terms that fines must be effective, proportionate, and dissuasive. So if the fine is not large enough to be dissuasive, then it's not complying with the GDPR. And that must be one of the reasons why it's so large. Although, again, I would question whether it's actually, well, again, I have to emphasize we don't know the detail, but it does seem very large. It feels high. Assuming there was no, you know, British Airways hasn't made any financial gain out of this breach. Its business isn't like Equifax, you know, for example, the trading in data. So it seems to me that it's being punished because of the size of its turnover, but not the size of its turnover that relates to sort of the dealing in personal data. And so it, you know, it just feels high to me, gut-wise.
Do you think there's a policy impulse behind that maybe it's a desire to try and change the culture, to try, you know, regardless of whether the markets respond, at least with a responsible company like British Airways, that the management culture might shift and there's an impact in that way? Would it be, or is it a broader message to the market?
I think it's, well, the GDPR was meant to be a game changer. It was meant to be a switch from the sort of rather box ticking regime of our old Data Protection Act. And, you know, if fines like this, which grab attention in boardrooms up and down the country, are going to become more prevalent, and the Information Commissioner says she's got about a dozen more cases about to be announced, you know, then the GDPR will be a game changer. There is a view, possibly a cynical view, that well, two things. One, that the Information Commissioner's sort of targeting, you know, a high-profile breach to set an example, as I say, to grab attention, which this has certainly done. And secondly, there's also an even more cynical view that this is the UK's ICO flagging to the rest of the EU that indeed its data security measures are adequate, and therefore very shortly after Brexit, even when that ever happens, the EU should, you know, promptly declare that the UK's data regime is adequate for EU GDPR purposes. So this is saying, you know, yeah, we take our data responsibilities seriously, so respect us.
I certainly like the cynical explanations. One of the things, simply because I'm sure there's a grain of truth in them, but that's a cynic in me. So, but one of the things that I think is a contrast. I mean, your point about the Hong Kong laws being like the UK laws of the 1990s is right on point, because the original Personal Data Privacy Ordinance in Hong Kong came into being in the 1995-1996, that kind of time frame. And it's only received one update since, in 2012. And that update was largely incident driven. It was because of a personal data issue, a personal data breach around Octopus cards, which is a stored value facility or an e-money type facility that's available in Hong Kong. And this Cathay Pacific incident feels like, in terms of the public reception of it, a similar type of event that might drive at least some change in respect of the laws here in Hong Kong. And it's more likely to be around bringing in a mandatory breach notification, because one of the things that when you read the report that the Privacy Commissioner issued, the Privacy Commissioner didn't make any finding about the more than 6-month delay in notifying anybody, including the data subjects, in relation to the data breach, because it wasn't a breach of the ordinance. But made some comments or observations about it, being maybe contrary to the expectations of what the Privacy Commissioner would hope an organization would adhere to, or what data subjects might want. And that tapped into you could say the PR aspects of it, which in Hong Kong tend to be the more effective sanction in terms of the more serious data breaches, because cybersecurity attacks now have become so commonplace that it almost needs to be something extreme in terms of size, in terms of the type of data that's being accessed and so forth, before it really catches the attention. And given the way Hong Kong operates, it's those kinds of events that might ultimately lead to evolution of the laws and improvement of the regulations.
Yeah, well, that's sort of the history almost of the introduction of the GDPR. That it's true that even under the GDPR, the sort of reputational damage that can be caused by a breach of personal data and the loss of customer trust is, and also on the other hand, the sort of benefits that can be gained by showing that you really do look after data. I mean, those are, I must say, until the British Airways fine was announced, those I always thought were the real motivators for GDPR compliance, the sort of positive PR that you can get from being a really trustworthy business, and the damage that it can do to your reputation if you're not, far more than fines. And again, I've read commentators over in the UK here saying that fines and data breaches are so commonplace that fines are going to become quite commonplace, and therefore for enforcement purposes, we're going to start to see prosecutions of directors for failing to take the necessary steps to comply with GDPR, which will be difficult, having to prove intention and all those kinds of things. Yeah.
I've also heard some issues around whether people can take out insurance to cover against fines. Maybe the fact that fines, particularly in relation to things that might have a criminal component to them, are not insurable, might also give people pause for thought. But I guess if you put people's liberty or their own personal name on the line, then that would have quite a heavy weight for people to think about what their responsibilities are.
Yes, I know that lawyers are frantically looking at and insurance companies are frantically looking at their law books as to whether you can insure against the consequences of your wrongdoing. And the cases are not terribly clear, unfortunately, in the UK at the moment. It depends on the sort of degree of moral turpitude, which is the wonderful phrase that is used. But yes, you can, I think, cyber insurance is obviously very common, but whether that can cover fines is a moot point at the moment. And you're right, we will start to see some decisions on that, I would think, before long. And the other thing that will happen, I suspect, is class actions and representative actions will start to crop up. Mm-hmm. And so, the 183 million might not be the end of the matter for British Airways. Well, it probably won't be the end of the matter. Of course, there's the possibility of appeals and so on, but the possibility of class actions, which the UK courts have been trying to sort of clamp down on or deter, because we don't want to become too litigious as a society, is the view.
I was just curious, the class action point, does that stem from GDPR, or is that more just an issue relating to whether or not it's possible in the legal system in place? I ask that because there was a similar expression amongst legal commentators in Hong Kong about would there be a prospect of class actions in Hong Kong. But frankly, within the Hong Kong legal system, it's just entirely frowned upon. I've never seen a class action really take hold because the courts tend to look at each individual case as being, you have to establish the individual causation, individual loss, and so forth. So it's very hard to get the framework right to bring a class action. So is this something that is enabled by GDPR?
It's only enabled to the extent that under the GDPR, individuals or data subjects who suffer as a result of a data breach or breach of the GDPR can claim compensation from the ICO or through the courts. But yes, like in Hong Kong, the UK courts are quite keen not to allow representative actions, as they're called in the UK, to sort of proliferate. So there's a case recently, Lloyd against Google, where the courts made it very clear that you couldn't start a class action as a sort of an officious litigator on behalf of people who really had no interest in having their interest represented in a representative action, and also that you had to be able to prove pecuniary loss or distress. You couldn't just do it because there had been a breach. I mean, I'm sure there are all kinds of law firms gearing up to represent litigants in class actions, but I think, or in representative actions, but it doesn't stem directly from the GDPR. It stems from the legal system, but it's obviously if you've got fines of 183 million and 500,000 customers involved, or I think it's 7 million UK customers involved in the Marriott International case, then the prospects of a class action interest.
And going back to our case, I just wanted to know if your expectation of, even if you have not enough information, probably, which are your expectation on a possibility of a revision of this very high amount of fine. You think that possibly with a good, let's say, good behavior of British Airways, the level of fine will be lower, or you expect to have almost the same fine that it was intended? Which are the expectations on this?
Well, the process, if British Airways hadn't been a listed company, there probably wouldn't have been an announcement at this stage, and there would have been some haggling and negotiating between the ICO and British Airways as to the level of fine, and then a decision would be reached. So it's difficult to know. I mean, as you say, we can't know what, the extent to which British Airways as a controller was responsible for the breach, or whether it was one of its processors. We can't know whether British Airways ignored advice, or we do know that apparently the breach lasted about 15 days. It seems to me to be quite a long time. We don't know how quickly they notified, but of course under the GDPR they're supposed to notify a breach within 72 hours. So so we don't know an awful lot. We don't know, but my expectation would be that, my guess would be that the fine will be negotiated down a bit, but not a lot, because the ICO won't want to be seen to be bending to the will of business. It wants to be seen as a regulator supporting the data subject, the interests of the data subject. And it wants also, as I say, to set an example, I suspect, and make boardrooms sit up metaphorically around the country. Okay. And of course, we do know that British Airways intends to appeal, or we think British Airways will appeal. So again, we don't know what effect that will have.
Everything to see.
Yes.
Yeah. And Padraig, I think we are going to move to the conclusion of this very interesting discussion. I would like to know if there is a kind of lesson learned or something that you think may be really constructive for your country that can be taken from what happened in UK with British Airways. Do you think that it can be used in the future as a kind of benchmark with the Cathay Pacific case to provide or generate new rules, new ideas, or you think that you think that it will be considered in that way? what happened in UK?
I think it's a coincidence that you had in relatively close proximity to each other fairly serious and impactful incidents that were reported on at the same time. So in that sense, to the extent to which there's a parallel or not, is more by virtue of the fact that airlines are data-rich companies, but they're not necessarily in the data business. And if you find that in those circumstances, still the standards to which they're required to adhere are very high standards. So in Hong Kong, the enforcement notice focused upon basically the obligation to take all practical measures to prevent unauthorized access to personal data subjects that you've collected, and that standard of all practical measures is a very high standard, even if you are not in the business of acquiring and processing data, as opposed to, in this case, arranging flights for people to go from A to B. So still the standards are very high, and I think that might be the principle that is consistent across both cases. That you can have businesses that are not in the business of personal data that must adhere to a standard almost to the extent that they were, because that's what the expectation is nowadays.
Okay. So I would like to ask both of you, if you have any conclusion on this discussion that you would like to raise.
My recommendation to businesses in the UK, indeed in Europe, is that they should be looking at their cybersecurity measures, as Padraig says. The required standard is pretty high. It's probably state of the art. So review your security measures, look at your contracts with your processors as to who's responsible for ensuring data security and maintaining data security over time. Look at your limitation of liability clauses, limitation of liability clause for, which limits the processor's liability to 5 million, which seems a lot of money, might not be enough in the light of the British Airways fines. So just review your contracts would be my thought, and look out for the British Airways decision.
Okay. You, Padraig?
I think that the lessons to be learned from the Cathay Pacific report are, again, just to focus on the security and retention policies that you have in relation to personal data, and also to make sure that you have proper ongoing monitoring, and ideally by independent third-party experts, because in the Cathay Pacific case, there were procedures in place, but the procedures weren't really monitored, and they weren't reviewed to make sure that they were consistent with what best practices were. So that kind of standard, to make sure that you don't have the subsequent PR issues that Cathay Pacific have had to manage, I think is really, really critical and important.
So thank you very much, Padraig and Kim. It's been a pleasure speaking with you and discussing about these two very interesting cases and their relations. And I would also like to thank all our listeners for joining us today. And I invite them to follow us at privacyrules.com and on our social. And I hope to meet all of you very soon again. Bye, everyone.